Presuit negotiations. So you've finished your medical treatment, you've collected your medical records, you have your bills, you have your evidence, you're pretty much done with your treatment and you have everything that you have completed. All the records, all the bills. Now, we gotta do something with them. We gotta start negotiating your case. But where do you start? Well, you have to assemble a document, usually called a demand packet. Some law firms call it a demand packet or package, but it's really an offer of compromise. That's the actual legal term for it. In fact, I like that term, an offer of compromise. Sounds much less condescending than a demand package. Come on, give me a break. We're going to give you examples of these offers of compromise. And it's very important to abide by the law. There is actually a law that talks about what should be included in an offer of compromise. That law is in a particular code section in the law. If you hear the words or the initials OCGA, that's just Georgia law. O, official, C, code, G, Georgia, A, annotated. That's what it is. OCGA, it's just the Georgia code, okay? This law is under OCGA 9-11-67.1. That's where we find the law on offers of compromise. You can put it in Google and you can find it and you can read it. But we also include the portion of the law in our offers of compromise. And the conditions that have to be put in, you can't say, hey, you have to pay me in a matter of 10 days. No, you actually have to give the insurance company 30 days. That's one part of the law. You actually have to say, well, if they do pay you, then who are you releasing? Who are you saying you will not go after their personal property? That's the person that hit you. You're not going to be going after their personal property if the insurance company pays you. That's the person you are releasing. So you must put that in your offer of compromise. You have to actually put the monetary amount. Like, how much are you asking for? You can't say whatever a jury believes is fair. No, you actually have to put the amount. And the amount has to be no more than what the policy is. A declaration page is what are the limits on a policy. You may know that in the state of Georgia, you have $25,000 minimum liability limits. You can have more. You can have 50, 100, 250, 500, a million, whatever, right? Declaration page actually will tell you what those limits are, and we're going to share with you a document that you can send to the insurance company that will enable you to obtain the defendant or their insured's policy. The amount cannot be more than the policy because an insurance company has a contractual relationship with the insured. And so you cannot ask for more than what the contract says. You have to talk about who's the claimant, that is you, that you're willing to release the defendant, which is the person that hit you. You have to say, when are you going to accept payment? So they have 30 days to accept, but that's different than when they're going to send the check. The law says that you cannot say, I need it earlier than the 11th day after the 30 days. So you really have 41 days. Those are the conditions in 9-11-67.1. We have these conditions laid out in these documents that we're going to share with you. So everything that needs to be included in an offer of compromise is really your version of events. Like, what happened? You were driving down the road, you get struck from the rear, you go to the emergency room. In narrative form, you just say it, right? And you say, hey, this is my offer of compromise to negotiate with the insurance company. I promise not to sue that person and go after his personal property if the insurance company pays me the entire policy. So it has a narrative of what happened. It has the summary of your medical bills. It has the amount of the bills. And if you have any physical evidence, I screenshot that bad boy. I screenshot it and I put it in my offer of compromise. So it's not like, oh yeah, we didn't receive it. Oh no, you did. You did, and it's right there. I want to share an offer of compromise that we sent on behalf of a mother and son. She's just moving her son in a stroller, and this person, not paying attention, hits them, right, in the parking lot. Thank the Lord they're not catastrophically injured, but obviously they're extremely frightened. Well, we were fortunate enough to find an actual video, a surveillance video of the incident. And what we did was we retrieved that video and we took screenshots of the video and we put it within the offer of compromise, right? And we showed how she was about 20 feet away and kept going, boom, and hit them, and they were forced 10 feet away from the car. And it really proves that she was careless, probably looking down at her phone, right? And we listed that and we made that argument to the insurance company. Well, the policy was $100,000 per person. $100,000 per person, and they ended up paying it. So that was $200,000 for these two individuals, mother and son. But it would not have happened if we were not able to obtain the video evidence to show how egregious the conduct was. So that's also important to include in an offer of compromise, because video evidence shows it as it is. It shows the truth of what happened. I call it justice in 1080p, but if you get a justice camera, it's actually 1296p. It's really important to have a dash camera. If you don't have a dash camera, you're just really, how can I say this? It's like you're driving a car without seat belts, without airbags, without anything to protect you. A dash camera protects your rights. Some of these cases that I have seen, it's impossible to explain how it happened without video evidence. Now, let's say that you don't have these types of injuries and you don't want an attorney. You don't trust attorneys, right? And you're just fed up. But you go ahead and do an offer of compromise yourself. You send it to the insurance company and you get lowballed. Insurance adjuster calls you up with a really rude tone and says, yeah, we looked at your medical bills. We're just going to give you $500. Take it or leave it. That's all we have. Now, people don't even know how to respond to that, right? Here's the first question. Did you receive all of the medical bills that we submitted? By the way, if you have a smartphone, there's an app called Tape-A-Call. It's probably $10, right? So it has all the calls that I have recorded, some with adjusters, some with attorneys. On an iPhone, you actually have to hit the record button, but on Samsung, I think there's another app that it actually records automatically. So anyway, this is what I do. So sometimes I get, by the way, all phone calls that come to my office are automatically recorded, so I don't even have to worry about that. But if it comes to my cell phone, it's like, oh, hi, Mike from Progressive. Could you hold on 1 second for me? Boom, hit the app, boom. Yes, sir, sorry about that, thank you. Now I'm ready, now it's recording. So I always do that. So now you are answering the phone from the insurance adjuster, right? Insurance adjuster says, hi, this is Mike with Geico. We're prepared to make an offer on your case. It's for $500. You're in your mind thinking, what the hell? I have $10,000 in medical bills. These don't even cover the medical bills. So you say, I want to make sure that you have all of my medical bills. And they're like, oh yeah, we do. It's like, how much, what is the amount of medical bills that you have for me? They are forced now to give you a number, right? And so they say, oh yeah, we have $6,500. And you're like, but we submitted $10,000 worth of medical bills. And you will find this a lot of the times where insurance adjusters just don't put in the right information. They don't even put the right information into their system. So the very first thing that you do is you must ensure that we're working off the same numbers. You don't start negotiating your claim. You actually ask, do you have all of my medical bills? I have an amount of $10,373. Oh no, we don't have that. Okay, can we go through them one by one to make sure that you have all of my medical bills? Okay, now whatever is missing, you just resend it to them. You do not verbally counter. You just resend it to them, make sure that they're operating off of all the numbers. Let me tell you a trick. Insurance adjusters like to say these words. Well, we've received them, but what we've considered is blah, 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 blah. Like, we've not considered all of them. What we've considered is $5,000 worth because we felt that was what was reasonable and customary, right? It's like, I understand what you're saying, but I want to know how much you've received. So just be careful. Do not ask them what they've considered. Ask them what they've received, okay? And if that number is off, make sure you send them the medical bills, all of your medical bills. And then make sure you ask these questions. Is there any dispute with respect to the neck injury that I sustained? Right? You're not telling them neck herniation, disc bulge, anything like that. You don't have to use any medical terminology. But is there any dispute that I sustained a neck injury? No? Okay. Is there any dispute that I sustained a back injury? No? Okay, great. Once you finish the phone call, you have that recording. You take that recording and you upload it on a beautiful website called rev.com, R-E-V.com, where they will transcribe everything that they said. Okay. Now you have proof that the insurance company is offering you $6,000, but they've received medical bills for $10,000, right? And you're entitled not only to the medical bills, but the pain on top of the medical bills. And so you now have the argument against them that based on this conversation, your insurance company is just offering whatever that they're offering. And then you reiterate your offer. And the reason you reiterate your same offer is because insurance companies think that they like to do this. I'm not going to bid against myself. That's what insurance companies love to say. We're not going to bid against ourselves, so you have to come down before we can go up. So I'd like to share with you another claim with Progressive where Progressive sent us a letter, and this is also going to be provided in your documentation. Progressive says, I have completed review of blank claim, and I am extending an offer of $23,050 for settlement of her bodily injury claim. Why did they say $23,000? Because we submitted $12,000 worth of medical bills, right? So, hey, that's pretty good. It's pretty good. You should take it. Well, we said no. We're not going to take it because this lady had something interesting in her medical record. She has something called posterior vitreous detachment in her eye, all right, where she started experiencing floaters in her eye. But floaters is one of those things that also happens just naturally, gradually, part of the aging process. They were giving me arguments of why they shouldn't pay even more money. One of the arguments was that it happens. Come on, it happens with everybody. You really think that this is caused by the wreck? So that's why we go through the medical record and we just decimate their arguments, right? And you'll be able to see this, but I'll go ahead and skip to this page 2 of our counter. And this is just another offer of compromise asking for the same amount of money. By the way, we were asking for $250,000. This is really the paragraph that was the most important, which was in our conversation, and I tell them exactly what they said. Progressive conjured 3 positions. The first one is that it was all a coincidence. The visual disturbances occurred 2 days after the crash were just coincidental, and the wreck did not in any way contribute to the retinal detachment. Progressive's second position is that this person had problems with her eye before the crash, since the retinal detachment occurs with normal aging, but never went to an eye doctor, and instead waited to be struck by a reckless driver in order to pin the retinal detachment on an innocent party. Progressive's third position is that even if the retinal detachment was caused by our insured, it's really not that. And $10,000 is reasonable to reimburse a person who has never asked whether they would take any money for their eyesight to be damaged. We again gave them an opportunity to pay the $250,000. Otherwise, we told them that we're going to sue for a lot more. They agreed, and they paid us the $250,000. So it's important in the negotiation to actually fully understand what are their arguments. What are they saying? Are they saying, oh, this would have just happened anyway? You have no proof of it. So really what you're saying is, my God, my eyes have been bothering me. I'm just going to hang around. I'm going to hang around to be struck just because then I can get reimbursed for my eye damage, right? That's what they're saying. So you really exploit that as much as possible.